Hello, welcome to Legal Action. My name is David Siegel. Thanks for joining us. Today we're going to be talking about joint parenting agreement as it relates to a divorce case. Joining me once again is my co-host Jesse Barrientos. Jesse, welcome to the show.
Thank you, Dave.
How are you doing this evening?
I am doing just fantastic.
Okay, great. Before we even start, I wanted to mention that Jesse is the co-author of the book Divorce and Family Law, Who Has the Legal Right When Things Go Terribly Wrong? And Jesse, very fine job on this book.
Thank you, Dave.
This book basically gives concise answers to complex questions regarding divorce and family law. I think it's really helpful that people who are picking it up are learning a lot about these topics so they're educated and they're aware of what's going to happen in their case, because there's so much uncertainty with this area of law.
That's true. It's very important to. Sometimes a lot of attorneys won't go into great detail with their clients about certain things. We certainly do at our office, because it's important. You're going to make a decision that's affecting your life, and you need to know all the ramifications and all the consequences that could happen from some of the decisions you might be making.
That's right. And in a divorce case, when there's children, there's nothing more important than the provisions that deal with those children. I don't care about the property distribution, the debt, division of retirement benefits. What it really comes down to in many cases when there's children is the important issues involving those children, because that's a lifelong commitment. I mean, technically you're only on the hook through college, but really children are for a lifetime. So let's talk about the law of divorce and joint parenting agreements as part of a court order as it relates to divorce and family law cases. Where would you like to start? What's the most important thing that everybody wants to know regarding their children?
Well, I think just a couple brief kind of statements here. I think that it's very important for both parties not to really involve the children in the litigation. It's going to be hard enough for them, and people might think that just because the children don't say anything or don't mention anything, that it's not going to have an impact on them. Children are very sensitive. Children know their parents, dependent upon the age too, and they know the patterns, and they know that there's a difference. They know that there's something wrong, and very often they think that they're the cause of it. And so it's exceptionally important for people out there to understand that, hey, listen, you know what? It's important to do this civilly, to leave the kids out of it. Don't use the kids as a pawn just because you want maybe more support, or you want to hurt the other parent because of what he or she has done to you or what you perceive that they've done to you. That's, I think, the most important thing that people have to remember.
And don't try and alienate the child's affections against one parent.
Absolutely. The only way that you should talk about the other person, and even if it kills you, okay, is to just talk, complimentary. Oh, that's your father, that's your mother, they love you. To just do positive reinforcement with the kids, because if you don't, that's exactly right. You're alienating them, and you're doing your kids, your children, a great disservice.
Right. And most of the judges want to make sure that that point is stressed. And if there's ever an issue at any point along the case, the court is likely going to order some type of mediation so that the parties know how to deal with each other vis-a-vis with the children. So that's court-ordered mediation, which is free.
Right.
Which is just a great benefit.
Well, it's mediation isn't free.
Court-ordered mediation is free.
Well, actually, I believe it is in Cook.
In Cook County, it's free.
Cook County. Okay, some of the other colored counties, I'm going to tell you, there's a charge for that. It certainly is not. There certainly are opportunities for pro bono that mediators have to do, or if the situation requires it. But in most of the other counties, there's a charge for that.
But it basically gets the parents on board with how they should behave, whether they can or not, with regard to the children as they're going through this very difficult process, because it's hard on everybody. It's hard on the parties, it's hard on the children, and it even gets to be hard on the court when it gets into a custody battle.
It does, and just kind of from our last show, we were talking about the difference between a contested and uncontested. Contested or an uncontested divorce, meaning you're in agreement on everything. You're in agreement on the custody, the visitation, on everything, and all you got to do is sign the papers and they get filed. Contested meaning, hey, listen, we might be in agreement that we're going to get divorced, but we don't agree on any of the specifics. That's still contested. So with that being said, it's important for people to know that if it is a situation where it's agreed, great. You come to, there's not going to be mediation because you guys are in agreement. What happens, though, is if you're not in agreement, then the court, the very first thing they're going to do is to order that mediation. And if you're in Cook, then you're not going to pay for it. But if you're in the other counties, that you will. But that's okay, because a mediator is somebody who is basically in charge of the process of trying to reach an agreement, and the two parties are in charge of the outcome. And basically what they tell you, and it's very true, that if you guys don't come to an agreement, and the goal is for them to come to an agreement, not for the mediator to tell you what to do or what not to do, but to be able to kind of lead you in the right direction so that you guys, the parties, can come to some resolution. Because otherwise, a judge who is going to hear a very thumbnail sketch of your life is going to make a decision that both sides are not going to like.
Not only that, it's better to compromise. Give a little, take a little, work out that agreement amongst yourselves. Otherwise, you're rolling the dice that the judge is going to side with you or with your spouse or come up with some kind of mix of the two that really neither one of you is happy with. So it's always best if you can work it out, and this goes for any case.
Sure.
If you can resolve cases, I know you stress that a lot. Even when I'm involved in some form of litigation, you said, Dave, will you settle this? Can anything be done to settle it?
That's what we try to do.
Yeah, it's definitely a good idea, and especially with a family. I mean, this is something that was brought together, hopefully based on love. A child or children are now a part of this family that's going to exist beyond this court event. So it's very important that they try and resolve it on their own. But the most important thing is who is going to handle the children, who is going to have custody.
That's right.
It's a misunderstood topic. There's many different types. I want you to elaborate a little bit about custody, what it really means, and what the court looks for.
There are various forms of custody. Generally, people talk about joint custody and sole custody. Sole custody means that the person, the parent who doesn't have the physical possession of the child most of the time, okay, the parent who doesn't have that, is not going to have any input in the kind of general decisions of the upbringing of the child, like religion, school, activities, those kinds of things.
So if I'm hearing you correctly, sole custody puts all of the burden, or the duty rather, on the person who has the child for the health, education, religious training, extracurricular activities, everything.
They call the shots, that's right.
And the non-custodial party, the party who has visitation, has no say in the day-to-day decision-making or even in the important events. Is that correct?
That's correct.
So sole custody would not be a good situation for, let's say, a father who wants to be involved in the decision-making. That father is not going to want sole custody with the spouse.
Right, that's true. However, you know, there are some other things that we need to look at. Let's look at the opposite side of that coin, and that would be joint custody. Joint
Sure.
custody means the opposite, means the non-custodial parent, the person who doesn't have the physical possession or residential custody of the children most of the time, does have a say-so on the day-to-day decisions, does have a say-so in the upbringing of the child when it with respect to you know, the activities, with respect to religion, with respect to schooling, and all those kinds of things. However, joint custody is only for people who can get along as it relates to the children.
That's right. I also want to clear up this misconception that joint custody means each party has the child an equal amount of the time, and that the child or children are being shuffled from house to house because they have joint custody. That's not the case, is it?
No, that's not the case, and we'll talk in a minute about you know, a kind of hybrid of this, joint residential custody. But just like in any relationship, there's no 50-50. You know, sometimes it's 60-40, sometimes it's 70-30, but in the long run, you know, it's 100%, and you need that really from each party to make any relationship work. And you know, the same is true with the kids. It requires everybody's 100% effort. You know, it might not be 100% on this particular day. It might, you know, go the other way, but you know, that's what it requires over the long run.
Now, is joint custody something that gets negotiated down at some point? Are a lot of cases where they start asking for sole, exclusive custody, and then in the settlement process it turns into, okay, I can work with him or I can work with her. We can share in some of the responsibilities and decision making. Do you see that more and more?
Yeah, sometimes it happens, and it depends. I mean, you know, perhaps sometimes after people come back from mediation or after they've had an opportunity, if one person is very steadfast on wanting joint custody and the other person is not, then if you can't come to agreement, then it's going to be a trial and the judge is going to make a decision. So it's a full-blown custody trial, which is going to cost both parties a fair sum of money, and it's not going to be any good for the parties. It's not going to be any good for the kids, because as I mentioned earlier, it's still going to impact them, because, and we'll talk about the different kinds of things that we need to do, but the other type of custody that you were maybe, I think, talking to, and people are confused about that, is the hybrid of custody, which is kind of what they call joint residential custody.
Now, it's very rare.
It's very rare, and
and there's a reason it's rare.
There's a reason. It's the exception. You know, those are for people who can get along. Joint residential custody. It's for people who are in a fairly close proximity. Generally, it's for folks who have pretty much shared the duties, where the kids are here at the one house, and then there's another house that's not so far, and both parents bring the children to school and drop them off. The reason why courts are not so inclined to grant that, and they want to look, and the standard is the best interest of the children, is because they don't want a whole lot of shuffling, because that's not in the best interest of the kids, for them to be shuffled, okay, from here, they're going to have to take an hour and a half car ride over here, or 20 minutes, and they're scattered. Children need stability. And unless that's been the status quo, sometimes people are separated for a while before they get a divorce. And they kind of just go ahead and live their lives, and they fall into certain patterns, and that's great because they do that by agreement. Right. And so in those rare circumstances, that is an alternative form.
Right. And just as an ancillary to that, the court does not like to necessarily divide up children.
Right.
Where sometimes we hear cases where wife wants the daughter, husband wants the son. That could be very dysfunctional for these siblings to be in separate households.
And sometimes neither one of them want little Johnny, you know?
That's true.
So it's, yeah, I mean, it's really, each situation is unique. And so, but generally, as a general rule, no, in terms of separating siblings, because they have that connection.
Yeah. Are you comfortable with custody? Can we move on to support?
We certainly can. I just would like to mention one thing.
Sure.
If it's going to be a contested matter and people aren't going to agree about that,
yes,
the court looks at various factors. They look at the desires of the parties. Now, of course, that really cancels each other out, because you want them and I want them. Okay. They look at the wishes of the child, and the children. It just depends on the age. If the children are 1 or 2 years old, then their decision, even if they can articulate it, doesn't have great weight. If the children are older, like maybe teenagers, then their decision has greater weight in the determination of where they're going to go. But it's still just a factor. They're going to look at any history of domestic abuse or domestic violence in the past. They're going to look at the people that are going to interact with the child.
Right.
Essentially, they're going to do that, but a lot of times what they do is they employ or appoint a guardian ad litem, which is an attorney for the child, who's going to,
or a child rep,
or child rep.
There's two different breeds now.
Right. Actually, there's a third. There's a third one. Right. There's a guardian ad litem, attorney for the child.
Right.
And anyway, so
what's that person's function? That's important.
That person is again, you're represented by your attorney. He's looking after your best interest. She's represented by her attorney. She's representing her best interest. And so the child needs to be represented. Now, generally, what will happen is it'll always be a guardian ad litem, not a child rep. Okay, mm-hmm. And so because it goes beyond our show here, there are different things that are required of each one of those things. So, but generally, it's going to be a guardian ad litem, and they're going to look after the best interest of the kid, and they're going to make a report to the court and tell them what they think the best interest. Now, there's also what they call a 604B expert, which is a psychologist that's appointed by the court. It's the court's witness, and everybody's going to get psychological evaluations. They're going to come in. The psychologist is going to administer tests.
But I don't need a psychologist. I'm just going through a divorce here. Why do I need a psychologist?
That depends on who you ask, Dave. Anyway, right. But in order to determine the child's best interest, that's what they're going to look at. And so the court is going to give great weight to the decision of either the guardian ad litem, what their recommendations are, because the guardian ad litem is the right arm of the court, and so it would be with the psychologist too.
Right. But judges are reluctant, are they not, to actually go to a full-blown hearing on custody? Aren't they going to try and encourage, even in this process of having the psychologist, they're going to encourage the parties to work out an agreement amongst themselves regarding custody?
Right.
I mean, how many times does it actually, percentage-wise, do custody battles actually go to a full hearing to determine custody?
Well, I mean, there's a lot of them, but I mean, in any litigation, you know, it's a small percentage of them that actually go to hearing. And of course, the judges are always everywhere because they're interested in resolving it.
Yeah.
And for for clarification, you know, we had those three classifications. We had the guardian ad litem, we had the attorney or the child rep, and we also had the attorney for the child. Those are the three kinds of categories. And again, just for clarification, because I don't think I mentioned that last one before. But anyway, yeah, the judges are going to try to resolve that and move that and push it because that's really what's in the best interest. So it's really a horrible thing because the child is going to get questioned. The child is going to go to this psychological evaluation, and they try to do it the best way they can. But essentially, most of the time, the courts are going to listen to what those people recommend.
Yeah, it's litigation the child did not ask to be part of.
That's right.
Let's move on to support. The person who has physical custody of the child on a day-to-day basis is entitled to child support.
That's correct.
How does that work? Is it in terms of percentages? Is it in terms of dollar amounts? How long does it last? Elaborate on child support if you would.
Okay. Child support is a right of the child, and you can't waive it. It can be reserved, however, under certain circumstances, and we'll talk about those in a moment. Generally, in Illinois, we have the guideline for child support. For one child, it's 20% of the net income. For two children, it's 28, 32, and it goes on.
And net income is income from all sources, correct?
An income from all sources except you get to deduct taxes, you get to deduct union dues, you get to deduct insurance premium payments, and that includes dental, health, that includes life insurance. You get to also deduct any mandatory pension.
Must be mandatory.
Must be mandatory. You get to deduct the expenditures for the necessary production of income, and that gets a little hazy depending upon what that is.
But very importantly, it's out of the net, not out of the gross.
It's out of the net.
Out of the net.
Right. And by the way, just so that the people at home know, it doesn't mean that you go to your employer and you take out more or less exemptions so that most attorneys, matrimonial attorneys, have a program and they put the numbers in. And so what it does is it calculates what it should be despite what you put in terms of what you're taking out in those taxes, because it's not. Because it can falsely deflate your income.
Yeah, that tax calculator is also available online for free. Mm-hmm. So people can look into that if they want to know if their spouse is taking out the proper taxes out of their check.
And then you have a choice to get the child support can be paid either directly to the individual. In other words, okay, give you a check, I pay you directly, or it can be taken out of my check for a notice of withholding and paid directly to you, or it can be taken out of my check and be paid to the state disbursement unit and processed and then paid to you. But if you do that last step, there's a small administrative fee. I think it's like $30, $35 a year for that to happen. But I would recommend to everybody that you keep a spreadsheet, that you keep check stubs and make a record of it, because the state disbursement unit, a lot of times those records aren't accurate. And if there's a problem in the future, you want to be able to prove what you've paid and when you've paid it.
The government agency that's set up to collect the child support and distribute it, how are their records inaccurate?
I found that they are not always accurate in terms of the specific amount that's owed, and in terms of maybe missing some kind of payments. They're generally okay, but if we're talking about a huge amount of arrearage, you want to make pretty sure that that's exactly what it is. And the only way to do that is looking either at their records, or if you've got the hard data, your copies of your checks and your own spreadsheet as you're going along to do that, it's going to make things a whole lot easier.
I always recommend to go through the SDU. That way you don't have to depend upon your ex-spouse to decide when he or she is going to forward the child support. It's going to be extracted right out of their pay, sent to the state disbursement unit, and then to the recipient. So it's always a good idea, accounting or otherwise, if that person's working, you're going to be getting your child support, which is needed. That's support for the child. It's not support for the spouse. It's for the child.
For the child. And some people have a different idea in terms of that. Some people are okay with that. They don't mind paying because they understand it's their duty to provide for their children. And some people also, as long as we're talking about that, have an idea that, okay, well, if it's for the children, I want an accounting of everything that you bought for the children. If it doesn't total what I'm giving you, I'm not giving you that. That doesn't work like that. It's for the food. It's for the roof over their head. It's for the mortgage if there's a mortgage payment. It's for the utilities. It's for all of those other kinds of things. And so there's no accounting for that. Now, I mentioned that sometimes you can reserve child support. Now, you can't waive it, but you can reserve it. And what that means is we're not getting child support. There has to be a reason for that.
What would be a good reason for someone to reserve child support?
Well, one reason that's common is that somebody isn't employed. And so generally the court will make them go out and keep a job diary and look for employment and come back and report to the court. Another reason may be that during our division of property, and we talked in our last show that, for example, about the house and whatever percentage somebody's going to get, if, say, maybe there was equity in the house and I just said $100,000 in equity and I said, okay, well, here, I'm going to give you the house with all the equity as long as you get out of my name, and in consideration for that, we're going to reserve child support. But you have to draft it very specific.
Right,
so it's
because
important.
the court wants to be careful that the child or children are provided for.
Are provided for and are taken care of, exactly.
Because that clause, there's no telling what that person is going to do with the equity, whether they're going to use it for support or not.
But that's a reason. That's a reason for
the reservation.
For the court for reservation, and because you don't want, and that's why it's important to draft. And we're talking about drafting this agreement. It's important to be very specific in there, because what happens then if you do that, and then the other person comes in for child support? Well, you better be sure that the language is very clear, that what you've done and what your income was and all that. Now, another thing that can happen is, remember the guidelines we were talking about the 20%, 28%, 32%.
Yes, I was going to ask you about guidelines and whether or not they can be deviated from.
Right, and they can be deviated, and this is another good example of how they can be deviated from. Let's say, kind of similar example, that there's a joint bank account and we have maybe $20,000 in it, and it's going to be split
Equally?
Well, equally. So there's $10,000. So, we're kind of figuring how much I make, what my net is, and what the difference is. And so we say in there specifically that it's deviating from this amount because she's receiving additional monies. There's another reason, actually, I just dealt with this not very long ago, where they had joint custody, but during the summer, the whole summer months, the 3 summer months, the children were going to live with the father. And so he wasn't going to pay child support for that time because the kids are with there, and they negotiated and they agreed. So what we had to do was figure out how much those 3 months of child support translate to, and we figured that out, and then we deducted it proportionate to the rest of it.
Or just take 9 months of child support and divide that by 12 to come up with what the monthly amount should be.
But then you have to specify in the judgment and the support order why there's a deviation. And as long as there's a good reason, like some of those things, the judges are generally inclined to go along with it.
Right. The other reason would be for a deviation if you have a breadwinner who's making an excessive amount of money. The percentage of the guideline percentage for support would yield an amount that is way too much or way more than what is required. For example, an athlete that makes $2 million a year, 20% of that net would be an exorbitant amount, and the court would not require that athlete to pay 20%.
That 20%. Most likely not. However, I can tell you that the court is going to want the children to share in the wealth of that parent. So, again, we talk about best interest. So it might not be 20% of of that $2 million, but it's not going to be just a bottom line kind of figure either.
Let's touch upon visitation,
Sure.
because whoever doesn't have physical custody wants to have, in my opinion or in my experience, a lot of visitation, a nice schedule when they can rely on seeing the children. What's the standard that the court looks to in terms of visitation, and can this be deviated from?
Well, first you have kind of what the general standard for visitation is, and some counties have their outline what they consider standard. And generally, it's going to be a visitation every other weekend from Friday after school till Sunday, depending upon how old the kids are, till about maybe 8 o'clock or so, just depending on how old they are. And perhaps one day during the week, not an overnight, but one day during the week where mom or dad could come and take the kids out for dinner and spend a little quality time with them. And then we talk about the holidays. Generally what happens is the holidays are alternating. So one year you get Christmas, the next year I get them. One year you get Christmas Eve, the next year and you adjust them so that I don't really have Christmas Eve and Christmas, although the parties can agree on that.
Sure.
Whatever you agree on as it relates to the visitation, generally the courts are willing to go along with.
It always saddens me a little bit when I see one of those alternating weekend fathers out with the child, because it's pretty obvious when a father is often with the child and there's no mother around and they're doing, alternating weekend dad type of activities. And it always kind of touches me a little bit that that person did not have the ability to grow up with both parents together. You feel the same way?
I do, and this is the best you can do under the circumstances, really. It's important to note, though, too, all right, for the agreement purposes, right, that you want to know and you want to specify who is going to pick them up, who's going to drop them off, and when they're going to do that, you want to have a late provision in there so that, hey, I'm not going to have to hang around indefinitely if you're late. That you have to give me a call and all those things. It also provides for telephonic visitation. In a joint parenting agreement, there's a special provision that's a mediation provision. That means if the parties can't agree as it relates to the children, first you have to submit and it can be drafted a number of ways, but generally the way I do it is they first have to submit their written request to each other to try to resolve it, and then if they can't, they pick a mediator, and then if that doesn't work and that falls through, then they come into court as a last resort.
I think as we come into more and more of the computer age and the internet age, we're going to see a lot more visitation via computer, whether it be through Skype, where the child can sit in front of a monitor and meet with the non-custodial parent at a specific time for a specific duration so that they can actually see each other when they're not in each other's company.
Sure,
I think we're going to see more of that.
Yeah, there is cyber visitation. That's a great idea because it kind of exposes it, try to kind of cure the little bit of the alienation stuff. There are a couple other things I think that we could touch upon.
Let's do it.
One is the education of the children in terms of college. It sets out the statutory provisions. Basically, everybody's expected to take a part and contribute. It depends upon your respective incomes, and it's split proportionately to how much it's going to cost. It requires the kid to have an aptitude, the child to have an aptitude for the college, and and those kinds of.
But the child has to apply for loans first and exhaust
sure.
those kind of alternatives before looking to the parents, correct?
That's part of it as well.
And that's Section 513 of the Illinois Marriage and Dissolution of Marriage Act that determines that, correct?
Exactly, Dave. There are a couple other things, because I think we're a little bit short here on time, that we usually have in our agreements. We have an insurance policy, because it's important for if anything happens to the non-custodial parent, there won't be no more support. So it's important to have a backup to protect the children's interests in the future. And generally, they, that goes to my agreement. I think that both parents should have it, because what happens if something happens to the custodial parent?
Right.
Then they're left with something. So I always try to encourage when I'm on either side.
So that's the provision, the nest egg for support in the event that one of the parties is not available to provide any more income.
Yep.
Okay. Any other particular topic that you want to cover in terms of custody, support, visitation?
Well, I mean, we could continue to talk more and more about that.
I think an important one before we go, and we just have a minute,
Sure.
would be the tax dependency, because this is a big deal,
Sure.
especially if you got both parents that are working. Can you talk briefly about how that works?
Well, generally, what I've seen them do is divide them up, and they do an alternating system. So basically, I have one of the children, and you have one of the children, and then when the older child gets emancipated, where I can no longer claim them, what will happen is we'll alternate years for that younger child, and that kind of equalizes it out. Unless one parent isn't working or making a certain amount of money, then they'll give them to the parent who is making more and paying child support.
So the court tries to do equity.
Right, but one real thing real quick is they will take that amount into account in terms of child support calculation, just so that you know.
Thank you, Jesse.
You bet.
Thanks for joining us on Legal Action. We handle divorce and family law, custody support, and visitation. We'll see you next time.